There's a school of thought amongst some people involved in this area that the law either doesn't or shouldn't have any application to crypto assets, smart contracts, distributed ledgers. And it's sometimes said, well, the law isn't really relevant because dealings are affected by non-legally binding consensus, because you're using cryptographic authentication, using strong methods, which means that effectively transactions are irreversible, because you've got decentralization and disintermediation, and so there isn't any central or responsible party who's amenable to court orders anyway. So there is that school of thought, and it was partly for the purpose of dispelling such iconoclastic views that a body called the UK Jurisdictional Task Force, which is led by Sir Geoffrey Voss, who's the Chancellor of the High Court, commissioned a legal statement on the status of crypto assets and smart contracts under English law. And the aim of that statement, of which I'm one of the authors, is to try and consider the extent to which English private law, it's not regulation as such, but English law, provides sufficiently certain foundations for this kind of business, and whether there were areas of controversy that needed to be addressed. And we had a very extensive and very enthusiastic public consultation on this process. I don't know whether anyone here was involved, all about what the statement should cover and what questions we should answer. And the two main topics that in the end we were asked to consider were, first of all, crypto assets. What is their status in law? What's their status, in particular in the law of property? And secondly, smart contracts. Are they the sort of things that the law will enforce, and how do they compare with regular contracts? Now, unlike many foreign legal systems, English law is largely uncodified, and it develops incrementally on a case-by-case basis. And this actually has made it very adaptable, and over the years, and indeed over the centuries, you see English law adapting by that process to all sorts of new technologies, many which were at the time just as novel and disruptive as the sort of thing that we're considering. That doesn't, of course, mean that the legal position in crypto is entirely clear or free from difficulty. But I think it does mean that from a legal perspective, we as lawyers should be a bit cautious not to be carried away with the sort of hype and enthusiasm about this and thinking this is an entirely new world. What we have to do is focus on what's genuinely novel about crypto assets and smart contracts from a legal perspective. And that exercise is, of course, somewhat complicated by the fact that not everyone is talking about the same thing when they talk about these products. And obviously, you've got a range of possible models from, on one end, public, permissionless, anonymous, decentralized systems like Bitcoin and Ethereum, and at the other end, private permission systems run by IBM or whatever. And they raise completely different legal issues. Now one particular aspect of legal difficulty also is that if you're dealing purely with crypto asset tokens like Bitcoin or Ether or something like that, which are essentially, as I've heard it described, just sort of in-game items, purely electronic, then perhaps you can leave it to the system to run itself. But in most business applications, at some point, there has to be some link between your crypto asset system and real-world objects. So if you're using a blockchain, for example, as tokens to represent something moving in the supply chain, there is some physical external object out there. And the crypto system can't control access to that. Ultimately, you're going to have to go to court, you're going to have to go to law in order to enforce what legal rights your crypto assets you think gives you in the physical object. So there's always going to be some point at which you have to engage with sort of real-world legal processes. Now, the legal statement itself is not due to be published until the week after next. So I'm not going to give you too many spoilers as to what the answers are to some of these questions. But what I have done instead, though, is to prepare a short problem sheet to illustrate some of the problems we've had to think about in the legal statement, and perhaps more importantly, to try and illustrate to you why they actually matter and why, why this isn't just a purely academic exercise. And these problems are approximately in ascending order of difficulty. So we'll see how we get on. And we're just going to start with a relatively easy one. So suppose that Alice has a crypto asset in the sense that she holds a private key to it. Let's not worry about what kind of asset it is. And then she's declared bankrupt. And a trustee in bankruptcy is appointed over her assets. And he goes to court to order Alice to transfer her crypto asset to him so that he can use it to distribute to Alice's creditors. And then there's a dispute between Terry and Alice as to whether that order should be made. Now, who should win that contest? Perhaps you could just have a show of hands. Who thinks that Alice ought to win that case? Right. And who thinks Terry ought to win that case? Right. Okay. So that doesn't seem very controversial. And the reason that it doesn't seem controversial is that it's essentially raising a question of legal policy. And if you are bankrupt, then anything you have of value ought to be available to your creditors. It's only fair. And that's a well-established principle of the law. And we can be pretty confident that the courts are, even though there isn't any legislation specifically dealing with crypto assets, that the court will interpret existing bankruptcy laws and rules in order to accommodate that policy. Now, of course, there is an entirely separate practical question relating to the enforcement of that right, because the court may well grant judgment in favour of Terry, but if Alice is unwilling to comply with the judgment and hand over the crypto asset or to divulge her private key, then how is that to be enforced? Now, in the traditional non-crypto world, much of legal enforcement depends on the cooperation of third parties, in particular banks, who can be expected to comply with or assist in the enforcement of court orders by freezing bank accounts and handing them over and so on. But in our example, if Alice flat out refuses to disclose her private key, then ultimately there is the threat, if she's within the jurisdiction, of imprisonment for contempt of court. But if she can't be brought before the court, there is no one else that Terry or Alice can turn to get assistance. And that's an important difference with conventional assets. Now let's move on to a slightly more difficult problem. So imagine again Alice holds a private key to a crypto asset, but Hannah comes along, and Hannah is a hacker. She hacks into Alice's wallet, and she gets a private key from the wallet and uses it to transfer the crypto asset to Bob. Let's assume that Bob is entirely innocent of the hack. He thinks it's a genuine transaction. When this comes to light, Alice asks the court to order Bob to transfer the crypto asset back to her, because she says, this is my crypto asset. And Bob, of course, says, well, that may be, but I bought and paid for it in good faith, and I didn't know there was anything wrong with it. So two innocent parties, Alice and Bob. What should the court do? So who thinks Alice ought to win that case? Right. And who thinks Bob ought to win that case? Right. So a bit more of an even split there. Now this problem is important because it raises a rather more difficult and fundamental problem about what crypto assets. Yeah, certainly.
What about the person who issued the wallet because it got hacked?
Well, that's another problem. There may well be other people who are liable. I mean, for example, Hannah would be liable here, and it may be that if there are people who can also be held to be responsible, they may be liable too. But the question I'm focusing on is, as between Alice and Bob, who are both unquestionably innocent here, how should the law decide which of them has the better claim to the crypto asset? Now, as I say, that raises the question of what a crypto asset really is, or at least how the law should regard it. And the law, of course, is very, very familiar with tangible assets, things you can touch and hold and take possession of. And there are very well-developed rules about who owns a tangible asset and how ownership can be transferred from one person to another. And one of the most important rules, which sometimes goes by its Latin maxim, nemo dat quod non habet, is that you can't give legal ownership of an object to someone if you don't own the object yourself. So if we were dealing with a painting, if Hannah had stolen Alice's painting, let's say, and given it to Bob, or sold it to Bob, there is no question under the law that Alice would be entitled to take the painting back, because she would say, I own that painting, and Hannah was not in a position to confer ownership on anyone else. The difficult problem is, how does that concept of ownership apply to a cryptoasset, which is not only intangible, but doesn't really have any existence at all, other than as a kind of stream of information, a conglomeration of public data and private keys and ledger entries and so on. Now, the law also is very familiar with intangible property, but that is almost always in a legal context in the form of things like debts or shares that involve legal obligations. But in a system, in a sort of true public permissionless system like Bitcoin, there are no legal obligations. No one involved in Bitcoin assumes any legal obligations to anyone else. It's just maths. That's all it is. And so there's a question whether something which is neither tangible nor embodies any recognizable legal obligation can be regarded in any sense as being property. Well, so that's an interesting point, it's a good point. So intellectual property is a form, a special form of intangible property, which is recognized by the law as property. But the only reason it's is recognized as property is because of specific legislation that makes it property. So in order to make intellectual property property, it was necessary for Parliament to pass a law saying that it was. Now, of course, that would be one solution for crypto assets, which will be for there to be special legislation which deals with all these points. But the issue we've been addressing, and that's unattractive in some ways because, I mean, some countries have done that. Some countries have legislated, but the sort of fast-moving pace of the industry, as well as a sort of large range of different kinds of crypto assets, makes that quite a difficult exercise. And anyway, it hasn't been done yet and isn't likely to be done in the near future. So we have to make do with the sort of legal rules that we already have. And as I say, in some ways, it's more adaptable if you follow the traditional incremental approach than if you try and get a blank piece of paper and write out a new law with all the difficulties that creates. I mean, another difficulty in thinking about these is that you ask, well, what actually is a crypto asset? In one sense, it's purely information. And the law generally doesn't recognize pure information as being property which is capable of ownership. So that's one sort of set of problems. And then another problem is, well, if let's suppose one gets over that hurdle and the law can treat something as sort of ephemeral or as a crypto asset as property, what does that mean legally when we talk about transferring a crypto asset from one person to another? What do we mean by that? Is that the same thing conceptually as me taking a physical thing, a bar of gold, and giving it to you? In other words, there is one object that passes from me to you. Or is it, as I think it is, more accurate to treat a transfer as a crypto asset by Alice, let's say, from Alice to Bob, as effectively involving the spending and cancellation of Alice's crypto asset and the creation of a new crypto asset in the hands of Bob? It seems to me that when you think about what's actually happening in data terms, that may be a more accurate way of analogizing it, certainly more accurate than comparing it to the handing over of a physical piece of property where there's only one thing that can exist in one place at one time. Now, I mean, clearly this is an important question in a dispute like this. But actually, it's an even more important question more generally, because if it's right that Alice will be the winner of this contest, in other words, if Alice remains in law the owner of her hacked crypto asset, and if it's right that she can get the court to order Bob to return it, then she can potentially trace her ownership interest beyond Bob to anyone else that Bob might have handed the asset onto, just as if it was a painting. However many people it passes through, the true owner can always step up and say, well, that's mine. And that potentially creates the risk that anyone in the network whose ownership of a crypto asset or whose receipt of the crypto asset could be traced back to Alice, would potentially be at risk of a claim by Alice to recover that asset, which I suspect will be rather unhelpful for the development of this sector, because it would mean that those who are buying and selling assets in good faith based on what's on the distributed ledger are vulnerable of claims based on historical hacks and frauds. Now you have to wait for the legal statement to find out the answer to that. What I would say is I think it is important to recognise that although one, as it were, can conceptualise what's happening in this situation as a transfer of one thing to another person, I think we all know that's not really what's going on at the sort of system level. What you've got is a succession of pieces of data which are being digitally signed, which are resulting in the consensus regarding them as spent and other assets as having been created. And it may be that that analysis will solve what otherwise is a potentially unhelpful feature of crypto assets. Now, try the next problem. A little bit more difficult still, I think. So here again, Alice has her crypto asset, and she transfers it first to Frank, and then to Simon. And just to be clear, when I say she transfers it, what I mean is, and let's think about it in a Bitcoin context, is she uses her private key to digitally sign and therefore authenticate a transfer instruction to Frank, and then she creates a new digitally signed instruction of the same Frank asset to Simon. So she's double spent it. And now, of course, double spending the consensus on the distributed ledger means that it's impossible for both of those transactions to be accepted. But what happens, let us suppose, is I'm sorry, I've got this the wrong way around on the slide. What I meant is that the transfer to Simon is the one, so the second transfer is the one that's accepted in the blockchain, and the first transfer, the transfer to Frank, is not. Sorry, that should be reversed. So there's then a dispute between Frank, who was the first in time to receive the transfer, but didn't make it to the blockchain, and Simon, who was second in time, but his transfer did make it to the blockchain. So contest between Frank and Simon. Who thinks Frank, not on the blockchain, should win that contest? Ooh. Right. And who thinks Simon, second in time but on the blockchain? Right. So again, more or less half and half. More support, I think, for Simon, but clearly not. Clearly there's some controversy there too. Well, there are sources of evidence in the court, not limited to what's on the blockchain. Maybe Alice, maybe Alice told us, or maybe Frank said, "Well, here it is. I received it by. I've got this instruction, and look, I received it by email and I looked at my watch, and it was 8 o'clock." And Simon has to say it was 9 o'clock. So what we assume, but it's a fair point. What we are assuming is that there's external evidence, so outside the crypto asset system, which allows the court to conclude that that the first transfer was created first, but within the system, the sort of system time, as it were, the system only recognises the second transfer. So because the system, of course, is not constrained by sort of physical time, but is just about which makes it to the blockchain first. Now, I think it's going to be a bit of a division of opinion. I think most people in the industry, most people in the development industry would say, with some justification, that the whole purpose of having a distributed ledger system, the whole purpose of the technology, is to resolve these kind of disputes, and such that the ledger should act as a definitive record of who has the right to particular crypto assets. I mean, that's what it's for. And it might be said with some justification it would cut across the whole philosophy of these systems if participants could go around asserting legal rights to assets in the system which are not consistent with what's recorded on the ledger, and therefore not consistent with the consensus view. And certainly that makes perfectly sound commercial sense. And you could say, well, Frank may have been first, but he knew what kind of asset he was dealing with. He has to take that risk. So it makes good commercial sense. But it's not clear to me, at least, why that necessarily must be the legal position, or why the court would necessarily accept that. I mean, there are certainly lots of areas of the law where there are registers of title which are treated as definitive. So the classic example is a land register. So the register of ownership of land, and that is treated as a definitive register of who owns particular plots of land. And if you're not on the register, you don't own the land. If you are on the register, you do own it. And that's fine, but the land register only has that status because, again, there is legislation that gives it that status. So there needs to be some statutory intervention in order to give it that status. Another way to make a ledger or record legally binding in the sense of being definitive as between participants is to get everyone who participates in the system to enter into an agreement that they will be bound by the ledger and they won't challenge it. And that, of course, may be possible in a permission system where you have to sign up and therefore can be asked to sign up on particular terms. But again, in a public permissionless system, there won't be any legally enforceable contractual terms. So you can't, there's no practical legal method of forcing that agreement on people. A third way in which ledgers and registers can be treated by the court as definitive is where there's a long-standing custom or practice. So there are certain documents in the law, like bills of lading and other documents like that, which have always been regarded as definitive records of title. And over time, a consensus, a legal consensus, builds up, and the courts are prepared to accept that there's a particular custom in a particular industry about how people see things. And that's, it's possible that at some point in the future, courts will be prepared to accept that there is some kind of custom of that nature around distributed ledgers, but we're a long, long way away from that. So if none of those conventional routes apply, or rules apply, there's no statute, there's no agreement, there's no custom, why shouldn't Frank be able to argue that, well, I was first? I was first, Simon was second, and so I, Frank, have a better legal right, because that's the position as it would generally be with conventional assets. Now, again, you'll have to wait for the definitive legal statement for the definitive conclusion, but I think, again, the solution to what is otherwise a slightly unhappy situation, again, lies in understanding that although we are talking about transfers here, again, it's not like me giving a painting or a block of gold to someone else. And there is not one thing that passes between Alice and Frank and Alice and Simon. In reality, there are three things. There is a crypto asset that Alice had, which is spent and cancelled. There's a crypto asset that Frank has, which he has a private key to, which is a perfectly valid piece of information, but unfortunately is worthless because no one else will recognize it because it's not on the ledger. It's a perfectly good piece of data. And then there's another crypto asset that Simon has, which is a slightly different piece of data that he controls with his private key. And fortunately for him, it's that asset that everyone on the ledger recognizes as being the thing of value. Yeah.
Why is it not similar to a regular case that might apply in the law for money today? What if Alice had written a check to Frank and lost it, and then wrote a check to Simon, and then Frank discovers it and passes it, and we have a similar kind of interaction that would, I think, be resolved by the court exogenously to the payment mechanism. It wouldn't be resolved by going through canceling out transactions on any particular ledger. It would go through the process of release.
Well, so in a money transfer, you wouldn't have this problem. And the reason you wouldn't have this, let's leave out checks, because checks have a slightly, let's think about bank transfers. If Alice makes a bank transfer to Frank, then either it clears or it doesn't clear. Once it's cleared, her account's debited and his account's credited, and then she doesn't have the money to make the payment to Simon. And the reason that, of course, all works is because you've got a central authority, i.e. the banks, who are keeping the books, and the banks synchronize their books between them. And so that prevents the possibility of a double spend because the banks won't allow it. Well, in the check case, if he loses the check, well, then he's effectively agreed not to take, given up the money from her. Yes?
We're running out of
Sorry. Yes. Yeah.
There's advice to the government in the UK recently that does allow somebody to cancel the payment within 24 hours
Yeah.
in a bank transfer.
Yeah.
And then you do get into this problem later. Anyway, and we'll see. But
Yeah.
to figure that through.
That may be. I mean, in the bank context, I mean, you may end up with a situation where the bank ends up taking the loss. But because you're dealing with books that are synchronized, you don't have this problem. Have I got 2 more minutes just for one more? Yeah, I just wanted to very briefly deal with smart contracts, if I've got a couple of minutes. So another little problem, this time an auction. Alice decides to auction her crypto asset via a smart contract system on some blockchain or other. But there's unfortunately a coding error in her contract, and so it ends up being transferred to the lowest bidder rather than the highest bidder. And both Alice as the seller and Hugo as the highest bidder go to the court to order Larry to transfer the crypto asset to Hugo. So what should the court do? So again, who thinks Larry ought to win that case? Right. And who thinks Hugo is the highest bidder ought to get the asset back off Larry? Right. Well, again, it's an even split. So it's obviously the difficult questions here. I mean, just on smart contracts. I mean, I was reminded at a sort of similar event the other day by one of the speakers that, in fact, the expression smart contract was originally, as I understand it, essentially a computer science construct. And it was never intended to be a contract. It was simply an expression to express the fact that there was an exchange on the chain, which was in some way can be analogized to a contract. Unfortunately, all the lawyers, heard contract, and they thought that's a word I know. I know what that means. And so there's been this rather, to my mind, unnecessarily complicated debate about whether smart contracts are contracts. And you might as well say, are apples pears. I mean, they're just different things. They just happen to have the same word in them. Most of the time, when we talk about smart contracts, what we're talking about is not the contract itself, but something that implements what the parties have agreed. And in almost all real-life situations, there will be, aside from the code on the chain, there will be some form of prior agreement or prior exchange between the parties for which the smart contract represents the implementation phase. So, as here, it says Alice auctions a crypto asset via a smart contract. But in practice, there would have to have been some communication between Alice and the parties to the auction, saying what the auction was going to be of and how it was going to work. And so from a legal perspective, it's actually a much more conventional exercise. The exercise being for the court to try and identify what it is that the relevant parties have agreed and where the terms of their agreement are to be found, whether it's, just one second, whether it's in a prior exchange or in the code or wherever. Yes. Mm-hmm.
Statement which says in an enforceable fashion that Alice will and does and has paid the highest bidder, whoever that be.
Well, so it depends. There could be a situation in which the only statement Alice makes is the code itself, right? And in that situation, the court would have to look at the code to try and work out what was agreed. But in many real-life situations, there will have been some prior contact between the parties, in which case the court will have to look at that too. And as I say, this exercise of trying to work out what the parties have agreed and where the terms of their agreement are to be found, it may well be a very difficult one where you've got smart contracts, but it's a totally familiar one with the courts. Every day the courts are trying to work out, whether there being complicated exchanges between the parties, which bits of it represents their agreement. And this is just another example. Yeah. Well, that's an interesting question too. Pieces of software can't go to court, of course, so at least not yet. And so ultimately, anyone who is bringing the claim must be a person, and that person must in some way be able to identify themselves with. If it's a software agent, must be able to say, well, it's a software agent which I control, or I have a right to bring a claim for. Yeah. Right. Well, yes.
Okay, they were treating a robot very much like a company.
Yes.
How far do you concur with the point that robot is a company?
I think robots, there's a long way to go in terms of development of robots before English law is likely to treat them as actors. I mean, there's a whole different seminar we can have about artificial intelligence, but I mean, from a blockchain perspective, I mean, I suppose the potentially difficult point is that you may well be dealing, there's human actors, maybe a number of steps removed from, as it were, the on-chain actors, which may be, automatic trading agents, for example. And so you have to find some way of identifying those agents with their principles. But again, these are difficult problems. But they're problems which in a sense, come up all the time in different contexts in the courts. Yeah, the difficulty of agents and principles and who is responsible for what is, again, it's a familiar one in the courts. Yeah.
Not about your very provocative case, but
Yeah.
in your study of labor law, the preparatory to making
Yes.
have you identified anything that's missing in the technical aspect of the ledger that would make it easier or possible for the law to give expression to what you think people want the law to be?
Well,
Missing pieces of the jigsaw.
I think what I would say is that a lot of these problems arise because there is no agreement between the participants about how these things are going to operate. I mean, one point that's important to make is, I mean, I've been speaking about English law, and I sort of assumed all the way through that it's English law and English courts that will decide these problems. But that's not necessarily the case, and particularly, blockchains are not only not necessarily located here, but they're not necessarily located anywhere. And so there's a prior problem with all of this, which is actually deciding which law and which court applies. I think in a sort of real life commercial context, one of the things people need to think about very carefully is whether they want to try and solve some of these problems in advance by writing them in some way, contractually, to the terms in which people participate in their blockchain, and dealing with things like who owns the assets, how they transferred, what happens if there's a dispute, what law applies.
Perfect point. Okay, so thanks for speaking. Very clear explanation.
Thank you.
Are you going to be around for the
I am, yes, absolutely. Yeah.
Great, we're not saying that what they will do, making it happen, then the lawyers.
Right, right.
Thank you.
Thank you.